Hello and welcome to Verdictum. I'm Sheetal June, and in today's episode, we will talk about the legal dilemma courts are facing in deciding on live-in relationships of people who are married. Recently, the Punjab and Haryana High Court, while rejecting compromise between a policeman and his live-in partner, has said that it would be against public policy to recognize a relationship of two people who are already married to different persons. A single-judge bench of Justice Harpreet Kaur Jeevan thus rejected the anticipatory bail petition filed by the cop facing allegations of rape from his live-in partner. The court cannot stamp a live-in relationship inter se to married persons by granting them the concession of pre-arrest bail by way of accepting the present appeal. Polygamy is not permitted under the Hindu Marriage Act 1955, and permitting such a relationship by allowing the appeal and granting the discretionary relief of anticipatory bail to the appellant would give a wrong signal to the society, the court said. The FIR was filed under sections 354, 354A, 376(2)N, 377 and 506 of the IPC, as well as a section 31W of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. The accused contended that following the High Court's denial of his pre-arrest bail, the matter had been settled between the parties and the complainant was no longer wishing to pursue the case. However, Justice Harpreet Kaur Jeevan denied the appeal, highlighting that live-in relationships lack recognition in law. The court noted that the couple had voluntarily entered into a live-in relationship formalized by a deed on April 1, 2021 and had been cohabiting since then. Another single-judge bench of the Punjab and Haryana High Court last year had ruled that a couple living together without obtaining a divorce from their former spouse cannot be considered as a live-in relationship or a union equivalent to marriage. The court also stated that such an arrangement would constitute bigamy under sections 494-495 of the Indian Penal Code. Justice Kuldeep Tiwari, while observing that only purpose of the petition is to avoid criminal prosecution for adultery, dismissed the petition filed by the couple from Punjab who had sought protection from the court. In another such case, Justice Alok Jain had ruled that one's choice to live outside wedlock does not mean that the married persons are free to have live-in relationship with others during subsistence of marriage, as it would amount to transgressing the valid legal framework. The court deemed the petition to be a device adopted to have a seal and signature of the court on the illegal act of the petitioners violating the norms of pious institution of marriage. Concurring views are shared by Justice Sandeep Mudgil, who earlier this year held that granting protection to married people who want to be in live-in relationships with their partners would amount to encouraging wrongdoers and promoting the practice of bigamy. On contrary, the High Court of Rajasthan has clarified that the offence of bigamy does not apply if a married individual cohabits with another partner without formally solemnizing a second marriage. The ruling delivered by Justice Kuldeep Mathur came in response to a case where a married man faced accusations of bigamy by his wife for residing with another woman. Justice Mathur underlined that the offence described in Section 494 of the Indian Penal Code, which pertains to remarrying during a spouse's lifetime, only applies if a second marriage is formally conducted while the original marriage is still lawful. Living together does not constitute bigamy unless a second marriage is officially performed. Taking a similar kind of stance, the Allahabad High Court's Lucknow bench decided that married Muslim man or woman cannot claim the right to a live-in relationship since Islamic tenets do not permit such a connection while the spouse is still living. However, the court stated that the stance might change if the two people are unmarried and the parties, being majors, choose to live their lives in a way of their own. A division bench comprising of Justice A.R. Masoodi and Justice Ajay Kumar Srivastava made the remarks recently while hearing a petition by a Hindu woman and Muslim man who said they were in a live-in relationship seeking protection from police action. The woman's parents filed a case against the man, accusing him of abducting her and forcing her to marry him. However, not all the observations made by the High Courts are on the lines of personal laws. It was yet another single judgment of the Punjab and Haryana High Court that asserted that married people entering in live-in relationships cannot be denied protection. Justice Arun Monga ruled that the state machinery is obliged to protect them irrespective of police's view on morality of such relationships. He said that the right to human life is to be treated on the highest pedestal and cannot be taken away except in accordance with the law, irrespective of the nature of the relationship. The Delhi High Court has also noted that although live-in relationships are not legally recognized, they are not considered criminal, and therefore courts cannot impose their moral judgments on consenting adults in such relationships. A single judge bench of Justice Swarna Kanta Sharma emphasized that adults have the freedom to make such choices unless they violate any existing laws. Live-in relationships between two consenting married adults who are married to different partners has not been made criminal or legislated against. The court holds that the parties herein have the right to determine their own choices, life and actions, but at the same time should remain conscious of the repercussions it invites from their partners and its effect on their marriage, she said. The Supreme Court, in its landmark judgment of Indira Sarma versus VKV Sarma, wherein it recognized live-in relationships for the purpose of Domestic Violence Act, also categorized them as an arrangement that can take place between married individuals. It made an attempt to define relationships in the nature of marriage while urging the legislature to do the same so as to clear all the ambiguity. It's clear that when it comes to live-in relationship, personal laws are up against personal choice, and with the arrangement becoming more mainstream, a clear legal proposition giving finality to the issue might just be on horizon, or we can see a new bill on the subject in the coming times. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.